So welcome everybody to the 15th annual Roger Hood lecture, which is our first ever webinar in honor of our esteemed colleague and dear friend, Professor Roger Hood, who I believe is also in the audience today. So greetings from all of us, Roger, even though we can't see you or hear you. I hope all of you who've tuned in to watch the talk tonight are safe and well in these difficult times. And I hope also that we're going to be able to see you all in person next year. We are very fortunate to have the technology to keep the show on the road and to do this talk. But I have to say, I hope this is the first webinar of one and that we don't end up having to do this again next year. My name's Mary Bosworth. I'm the current director of the Centre for Criminology at the University of Oxford, and my role tonight is to chair the event. And as part of that, I will set out, before I hand over to the speaker, some of the guidelines for the event, which those of you who've attended webinars before will already be familiar with. But first, before I do that, I'd like to start with an overview of the lecture series and then also introduce you to this evening's speaker. As I've already said, this is the 15th annual Roger Hood lecture. This series, which was established in honor of the Centre's long-standing director, Professor Roger Hood, who directed the Centre from 1973 to 2003, is held this time each year. Starting with David Garland in 2006, each lecture has been given by a scholar of great international standing who is working on key criminological issues. Tonight's speaker is no exception. It gives me great pleasure, therefore, to introduce Professor Dirk Smit, Professor of Comparative and International Penal Law at the University of Nottingham. From 1982 to 2005, Dirk was Professor of Criminology at the University of Cape Town in South Africa, where he was also Dean of the Faculty of Law from 1990 to 1995. In 2012, he was Global Visiting Professor at the NYU School of Law, and in recent years, he has held appointments as a visiting professor at the Humboldt University in Berlin, the Paul Cézanne University in Aix-en-Provence, and the Catholic University of Leuven. Dirk is also an advocate of the High Court of South Africa. Over the course of his career, Dirk has published extensively on various forms of punishment, offering a critical analysis of practices across the world. His scholarship stands out in the somewhat crowded field of punishment and society in his attention to the potential for legal challenge and reform. His 2009 book, co-authored with Sonia Snacken, for example, Principles of European Prison Law and Policy, not only provided a clear account of European human rights law, but made clear how such rights could ameliorate conditions inside prisons. Similarly, his 2019 book, co-authored with Catherine Appleton, formerly of the Centre for Criminology in Oxford, on Life Imprisonment, a Global Human Rights Analysis, was not only beautifully produced, in the words of Alison Liebling in her review for the Modern Law Review, but has a very clear purpose: to supply all that anyone needs to know in order to critique and campaign against increasing use of the life sentence. This evening, Dirk will be continuing in this vein by drawing on his research on life imprisonment and other ultimate penalties, including the death penalty and the law. As he will show, while penal reformers have long fought to make ultimate penalties more humane, concerted efforts are being made in several jurisdictions to reverse this trend. The use of whole life sentences, denying prisoners all hope of returning to free society, is increasing. Countries with the death penalty, which also had life imprisonment with a possibility of release, are now adding whole life sentences with no hope of release. So this evening in his talk, Dirk will explore these counter tendencies and apparent drift towards authoritarian populism in what I'm sure will be a timely call for criminological and legal attention to the corrosive impact of harsher sentencing practices. Before I hand over to Dirk, just a brief reminder about how webinar events like this one work. Unlike an online meeting, this webinar allows for audience engagement only via the chat function. Dirk and I will be on the screen because we're panelists, but we can't see you or hear you. If you want to see him most clearly while he's delivering his lecture, then I suggest you put your screen to speaker view, and I will minimize and become a little rectangle. We won't be using the hand function. So if you have a question, please type it into the chat function. This you can find at the bottom of the screen, and if you click on it, it'll open a side panel where your question will appear. Please remember, everybody will be able to see your question. You can use the chat function while Dirk is talking. As chair, I'm going to be making a note of questions. Do try to keep the questions fairly brief, as it's a bit hard to read longer ones and then reply. I'll do my best to summarize them if they're long, and Dirk will respond at the end of his talk. If you can, remember, please only use the chat function, not the Q&A, just so that I only have to keep track of one set of questions. I believe Dirk's lecture will last for about 45 minutes, and then we have about 30 minutes for questions. The lecture is being recorded, but not the question and answer time. It will in due course be made available on the Centre for Criminology website and YouTube channel. So I will now hand over to you, Dirk. Thank you.
Well, thank you, Mary, for the kind words of introduction. It's a great honor to give the Roger Hood lecture, an honor underlined by having Professor Hood, as you've said, in the audience. I've admired Roger's work since my student days in Edinburgh in the 1970s, but I really got to know him well when, a few years ago, we worked together intensively in Malaysia to persuade the authorities there to abandon the death penalty. Roger's ability to combine rigorous scholarship with impassioned advocacy made a very deep impression on me. Penal reformers have long fought to make ultimate penalties more humane. Some, like Roger, have sought with considerable skill and success to hasten the abolition of the death penalty. Others are increasingly focusing on life imprisonment. There are proponents of the abolition of life imprisonment, but more common are those who would like to limit the imposition of life sentences and to introduce and to ensure that those serving life have a realistic prospect of release. I'll say something briefly about the latter, but what I want to explore in more depth in this lecture are counter tendencies to the trend towards fewer and softer, if you like, life sentences. I will consider the apparent drift towards increased punitiveness that takes the form of more life sentences being imposed worldwide than ever before, and a revival of provisions that facilitate, in law and in practice, the whole life sentences. The reality is that there are now more than 500,000 persons serving life sentences worldwide. A large number of these, possibly more than 100,000 in all, are serving sentences that are designed to ensure that those subject to them will never routinely even be considered for release. The United States of America, where most such prisoners are found, initially saw life without parole as a less drastic alternative to the death penalty. Its persistence, however, is facilitated by the acceptance that it has now become a normal punishment that may legitimately be used in cases where a sentence of death would never even have been contemplated. My primary focus this afternoon will be on recent emergence and subsequent normalization of formalized whole life imprisonment, that is LWAP, life without parole, as it's sometimes called, in places far away from England and Wales. I will go on to argue, however, that many countries that publicly aspire to being liberal democracies, including prominently the United Kingdom, have failed to resist the introduction of inhumane punishment. Not only is this failure unacceptable, but it has an impact far beyond national borders. Let me clarify some of the concepts that I propose to use. In order to explain the rise of harsher penalties, we often turn to the idea that their upsurge is driven by populist punitiveness. In recent years, there's been much research on penal policy in which the concept of populist punitiveness has been deployed. Much of this research has been concerned to explain why the public has become so punitive. In a wide-ranging recent overview, John Pratt and Michelle Mao also sometime of the Institute of Criminology in Oxford, have suggested that penal populism needs to be distinguished from other populist manifestations, in particular the authoritarian populism that Stuart Hall argued as far back as the 1980s as being involved in the imposition of a new regime of social discipline and leadership from above in a society increasingly experienced as rudderless and out of control. That was a quote from Stuart Hall. Pratt and Mao claim that, quote, the thrust of penal populism largely involves social movements and pressure groups campaigning from below for more punitive and more extensive criminal laws. They go on to identify a number of converging factors, ranging from a decline in deference to greater focus on victims of crime, that have all contributed to the rise of penal populism. While these factors are often present and interesting in their own right, rather less attention has been paid to how politicians and other powerful people interact with the apparent punitive stance of the wider public. Now, this is important because when Tony Bottoms first formulated the concept of populist punitiveness in 1993, he explained that he was referring to, and I quote, the notion of politicians tapping into and using for their own purposes what they believe to be the public's generally punitive stance. Even less attention has been paid to the responses of the judicial branch to what they may be perceived as a rising tide of populist punitiveness, and may then seek to accommodate, notwithstanding clear legal pointers that go in the opposite direction. What I want to concentrate on this evening is the impact in different branches of government of a wider authoritarian populism that not only recognizes punitiveness amongst the public, but on occasion indulges, encourages, and even exploits it. The effect I propose to show is that particularly, but not only in countries with regimes that are characterized by authoritarian populism, harsh punishments are being normalized. And I want to argue that this normalization needs to be challenged as vigorously as possible. Before I describe the various tendencies, let me first sketch briefly the backdrop of a more optimistic recent past against which they operate. The last time I spoke in Oxford, in late 2013, I was very excited. It was shortly after the decision of the Grand Chamber of the European Court of Human Rights in the case of Winter and the United Kingdom. In Winter, the Grand Chamber had ruled that every prisoner serving a life sentence must have a reasonable prospect of release, and that life prisoners should know at the time of sentence what they had to show in order to qualify for release, and what process would be followed to determine whether they qualified for release. The Grand Chamber also strongly recommended that release should be considered no later than 25 years after the imposition of a life sentence, with periodic reviews thereafter. English law, which gave the Secretary of State the power to order a release only where there were, quote, exceptional circumstances that justified the prisoner's release on, quote, compassionate grounds, was not sufficiently flexible to meet the emerging European standard. Moreover, the Secretary of State had defined exceptional circumstances in a prison service order as referring only to situations where the prisoner was terminally ill or seriously incapacitated. The Winter Court doubted whether allowing pushing out someone out of prison only in the last days of a life sentence amounted to release at all, as the prisoner released in late old age would have no real chance to become a full member of society again. Such hope, in the view of the Grand Chamber, was essential to ensure that the human dignity of the prisoner was recognized. Hope of being a full member of society again. In this way, the Grand Chamber linked potential reducibility to fundamental principles of human rights, and in particular to the prohibition on inhuman degrading punishment in Article 3 of the European Convention of Human Rights. Now, if one were to leave aside one later decision of the Grand Chamber, the case of Hutchinson in the United Kingdom, to which I'll return, the subsequent story at the European level would be about further progressive development of the Winter principles, leading to real positive changes in Europe and more widely abroad. In the Netherlands, for example, since Winter, the law now provides for the first time for routine consideration of the possible release of the relatively few prisoners sentenced to life imprisonment in that country. In Lithuania, an ineffective system of presidential pardon has been replaced by consideration of release after a maximum of 20 years and by a fairer procedure than before. And in 2019, the European Court ruled against an Italian law that made the release of life prisoners conditional on their cooperation with the judicial authorities and the permanent severance of their ties with organized criminal groups. This was because prisoners who were mafia members, for them release was practically impossible in some cases, as they would risk their lives if they worked with the authorities. Effectively, such prisoners had no prospect of release. This led to them losing all hope, and therefore it infringed the European Convention. The arguments on a right to be considered for release, as developed in the Winter case, have had an impact far beyond Europe. Courts around the world, sometimes in countries that would not be characterized as liberal democracies, have found these arguments persuasive. In Zimbabwe, for example, the Supreme Court was persuaded in 2016 by the reasoning in the Winter case to rule that it was unconstitutional to leave decisions on the release of life sentence prisoners to President Mugabe alone. The court ordered that, until the government of Zimbabwe came up with new legislation, all life sentence prisoners should be considered for parole after 20 years, in the same way as other sentence prisoners, thus significantly increasing their prospects of release. And in Belize in 2016, the National Court of Appeal relied on the reasoning in Winter to declare life sentences without parole unconstitutional. And the government of Belize responded by amending the sentencing provisions relating to murder and introducing a parole board to routinely consider the release of such prisoners. Now, one could multiply these examples, but so much for the progressive tendency for the moment. But unfortunately, ladies and gentlemen, concerted efforts are also being made in several jurisdictions to reverse the trend towards giving all prisoners a realistic prospect of release. In Central and Eastern European countries, which after the fall of the Soviet Union, with the exception of Belarus, all abolished the death penalty and replaced it with life imprisonment with the prospect of release, or with fixed-term penalties, the fight back for a harsher ultimate penalty has been led by Hungary. Hungary abolished the death penalty around about 1990, but there they introduced life without parole again as the signature policy of the Finnish party of Prime Minister Viktor Orban in 1998 already, when it first came to power. As Orban and his party in ensuing years became more authoritarian, life imprisonment became even more important in their political strategy. In 2010, in his successful campaign for a parliamentary majority, two-thirds majority for Fidesz, Orban returned to his theme, leaving the public in no doubt about his intentions. He announced, I quote, "After the elections, one of our first steps will be to increase the severity of sanctions. Life imprisonment without parole should be imposed for many further crimes. The full force of law, longer sentences, and the more frequent use of life imprisonment, together with greater protection of victims, will restrain offenders and make it clear to members of society that Hungary is not a paradise for criminals." What Fidesz did after the election was to push through a constitutional amendment, which is still unique in Europe, referring specifically to LWOP. Since 2012, the Constitution of Hungary has provided, and I quote, "Life imprisonment without parole may only be imposed for a commission of a willful and violent criminal offense." Although it's phrased in these permissive terms, The explicit purpose of this provision was to entrench LWOP. Its role soon became clear. In 2014, relying explicitly on Winter, the European Court ruled that the very limited clemency procedures then still in force in Hungary were unacceptable in European law. The Hungarian government first responded by revising the clemency procedures and providing for an automatic clemency review after 40 years. Note, 40 years. However, the new procedures still left the clemency decision to the head of state, who didn't have to give reasons for his decision. And in 2015, the Hungarian courts essentially said, fine, this meets European standards. In 2016, however, the European Court ruled that the 40-year period was too long to give real hope of release. And in addition, the new clemency procedures still didn't meet the requirements of the European Convention. As far as the European Court was concerned, these were still whole life sentences. Since then, what has happened in Hungary to enforce this judgment and eventually abolish whole life imprisonment? Precisely nothing. The Hungarian constitutional provision on LWOP has not been amended, and the Hungarian courts have not intervened to enforce the latest European Court of Human Rights decision. I understand that the majority of the Hungarian Constitutional Court now believes that while they are required to apply the European Convention, they do so as they see fit and do not regard themselves as bound by the jurisprudence of the European Court. Excuse me. About 60 prisoners are still serving LWOP in Hungary. LWOP is now a normalized element of the long-term punitiveness of Hungarian authoritarian populism. A more recent example relates to Poland. Poland, unlike Hungary, did not introduce LWOP shortly after it abolished the death penalty. Instead, it provided for a court to consider the release of all life sentence prisoners after they'd served a fixed period, normally of 25 years. In 2019, however, the Polish government changed course. At its behest, the Polish parliament, the Sejm, passed new legislation that lengthened to 35 years the standard minimum period before the release of lifers could be considered. It also introduced a new whole life sentence that could be imposed directly by the courts. Protests by national and international NGOs were brushed aside, as well as an urgent request from the UN Committee Against Torture for the Polish government to think again about the proposed legislation. The increasingly authoritarian government of Poland held the lie. The legislature that it dominated explaining that there was a need for, quote, severe repression of perpetrators of those acts that arouse strong social need for retribution and stigmatization. With regard to the provision of conditional release, the legislature stated, it should be applied to the most dangerous offenders, where both justice and prevention considerations speak in favor of not modifying the sentence at the stage of execution by providing for a set release date. It argued for life sentences, that for life sentences, the current 25-year period before release could be considered was too short in relation to, quote, the assumption that the sentence would eliminate an offender from society. The minimum period should always be at least 35 years, and courts should have as an option imposing a whole life sentence. That's one with no minimum period at all for the worst cases. As in Hungary, the current Polish government is characterized by its authoritarian populism and a court system whose independence has been under sustained pressure. Serbia is a third example of a European country that introduced LWOP for the first time, in its case in 2019. What's remarkable is that until last year, Serbia had no form of life imprisonment at all. Instead, it had a maximum sentence of 40 years. In passing, this followed the pattern of the former Yugoslavia, in which there was no life imprisonment, but only the rarely used death sentence, with fixed-term sentences as the effective ultimate penalty. Life imprisonment had been considered as an additional penalty for the most serious crimes in 2015, but it had not been pursued, as Serbian legal scholars and professionals had largely been opposed to it. What changed in 2019 was the emergence of a classic movement from below, built around the reaction to the rape and murder of a young woman, Tijana Juric. The Tijana Juric Foundation, established in her name by her father, campaigned actively for a new law on life imprisonment. After a short review process from which legal experts and human rights organizations were excluded, the government responded with new legislation that provided not only for the introduction of life imprisonment with parole to be considered after 27 years, but also for life imprisonment with no prospect of parole for a whole range of offenses. As a Serbian scholar described the outcome with a rather splendid, if possibly unintended, double entendre, it was a triumph for criminal populism. A close look at this legislative process reveals that while pressure from below played a crucial part, the Serbian government had a large role in converting the single-issue campaign into a wider movement towards a more authoritarian form of populism in which traditional rule of law safeguards were limited. What was at stake emerged from a three-way debate on Serbian television between representatives of the Tijana Juric Foundation, an NGO, Lawyers for Human Rights, and the State Secretary for Justice. What was striking was the extent to which the State Secretary, while congratulating the Foundation for the initiative it had taken, moved the debate towards wider issues. When taxed by the NGO representative on the likelihood that the European Court would reject the newly introduced LWOP sentence, the State Secretary commented not only that he doubted that it was certain what the court would do, he added, and I quote, "Ultimately, I do not care about that Council of Europe. I care that our children are safe, much more than what the Grand Chamber of the European Court of Human Rights will hypothetically do." Close quote. Another interesting aspect of the debate is how comparative law was applied. The United Kingdom was cited by the Foundation representative as the leading example of a European state that still had a life sentence without the possibility of parole. There was also a somewhat confused debate about the full meaning of the Winter Judgment, in which the two supporters of the new law sought to deny that it would outlaw LWOP in Serbia. Certainly from the transcription of the debate, I imagine that the Serbian audience was left in considerable doubt about the current European legal position, notwithstanding the long line of European cases that have held that in the absence of an appropriate procedure, the mere possibility of a pardon is insufficient. Nor is the issue of Serbian LWOP likely to be resolved soon. For although the Serbian Constitutional Court has been asked to review the legality of the new law, I'm told that may take another 2 years at least, and an appeal to the European Court even longer. Outside Europe, support for LWOP is stirring in two major countries. In India, which still has the death penalty but rarely carries it out, persons sentenced to life imprisonment were until recently routinely released after 20 years, as this was believed to be a legal requirement. In 2016, however, the Supreme Court of India intervened and confirmed that senior courts could replace a sentence of death with a form of LWOP that prevented routine early release. Thus far, this form of life sentence has been used in relatively few cases, but if it were to become the norm, it could have a massive impact on the overall prison population, as more than 50%, more than half of sentenced Indian prisoners are already serving life sentences. So imagine if you make them longer. And then since 2015, the law in China has also provided that where courts impose suspended death sentences, that is, death sentences that must be reviewed after 2 years, they may stipulate that if the death sentence is set aside, it may be replaced only by a life sentence from which no release is routinely possible, that is, by LWOP. Now, sentencing courts have been given this extraordinary power only in corruption cases where the death penalty is initially imposed. And the first indications are that it's not being used that often. Nevertheless, it too has the potential of leading to an increase in whole life sentences. So much for the worldview. The question that remains is, what has the role of the United Kingdom been in this ferment? When the Winter Judgment appeared in 2013, there was a predictable convulsion of popular punitiveness that was reported in the press. The then Minister of Justice, Chris Grayling, remember him, said that the authors of the European Convention on Human Rights would be turning in their graves at the activist direction that the European Court had taken, and he threatened to withdraw the UK entirely from its jurisdiction. The Prime Minister, David Cameron, remember him, was quoted as being very, very disappointed. He went on to say, "What I believe is very clear. There are some people who commit such dreadful crimes that they should be sentenced to prison, and life should mean life. And whatever the European Court has said, we must put in place arrangements to make sure that should continue." Close quote. At the time, I didn't take these responses seriously or see them as the precursors to a more deliberate authoritarian populism. The 16-to-1 majority decision in Winter was so unambiguous that I thought it was only a matter of time before English law and English practices would change to reflect what the Grand Chamber in Strasbourg had so clearly decided. I should have been more suspicious. In the event, the judgment in Winter did not lead the British government to amend in any way English law to facilitate the consideration of release, nor were any prisoners serving a life sentence pursuant to whole life orders released. Instead, it was the English Court of Appeal that intervened in the case of McLachlan now to consider the change in the post-legal landscape. And in early 2014, the Court of Appeal ruled that while neither the primary legislation nor the relevant prison orders had been amended, the existing statute in English law allowing only for compassionate release in exceptional circumstances could be reinterpreted in the light of the Winter decision. English law, according to the Court of Appeal, did now somehow allow prisoners with whole life orders to be considered for release before their last days. The court discounted the fact that the prison service order issued under the authority of the same Secretary of State that is responsible for release decisions still provided that life prisoners would in practice only be considered for release if they were terminally ill or seriously incapacitated. Unsurprisingly, in the light of this decision, after 2014, English courts continued to impose life sentences with whole life orders attached. Moreover, when imposing these orders, sentencing courts continued to tell offenders in the bluntest possible terms and without any qualification that they would never, ever be released. The question of English whole life orders was referred to the European Court again. And in 2017, in the case of Hutchinson, the Grand Chamber of the European Court of Human Rights unexpectedly, to me anyway, agreed with the Court of Appeal that English law could be interpreted as allowing release at an earlier stage than the Grand Chamber had previously concluded in Winter. It did suggest rather weakly that the prison service order that ostensibly restricted the discretion of the Secretary of State should be repealed. To put it politely, the interpretation of English law adopted in McLachlan and endorsed by the European Court in Hutchinson is at odds with the wording of the relevant statute. As the dissenting opinion in Hutchinson points out forcefully, the words compassionate and exceptional cannot logically be stretched to include the wider review required in vinter. Now, why did the Grand Chamber come to that conclusion? One senior European Court judge has openly claimed that a double standard was being applied, with British release procedures being evaluated less strictly than those of, for example, Lithuania, because of the fierce criticism to which the European Court of Human Rights was publicly subjected in the UK. The immediate response of the then Secretary of State for Justice to the decision of the Grand Chamber in Hutchinson made it clear that the British government never intended anyway for anyone subject to a whole life order to be released. She welcomed the judgment, commenting that it was, quote, right that those who commit the most heinous crimes spend the rest of their lives behind bars. The Sun added gleefully that, quote, the new ruling confirms Britain can continue to keep beasts caged until they die. The unfortunate effect of Hutchinson in England and Wales has been that English courts continue freely to make whole life orders. To this day, the prison order limiting release in practice to terminally ill or seriously incapacitated prisoners has never been repealed. In fact, to the best of my knowledge, no one on whom a whole life order has been imposed has ever been released. There are now 63 prisoners with formal whole life orders who will never be released from prison, and several more whose release is highly unlikely, as the date at which their release will first be considered is far beyond their expected lifespan. A solicitor friend tells me that when he recently inquired from government about how to apply for the release of a client serving a sentence that included a whole life order, he was met with incomprehension. He was asked to include in his representation an explanation as to the possible basis on which he considered the Secretary of State had the power to even review such a sentence. The wider message that it is acceptable to keep people in prison for the rest of their lives has been normalized in the UK. This development has not been lost on British politicians either, who now exploit this line of thinking. In its November 2019 election manifesto, the Conservative Party said, the next Conservative majority government will reform the law to make sure that the premeditated murder of a child leads to the imposition of a whole life order, meaning that a prisoner will never be eligible for release. That was a quote. Well, we now have that Conservative majority government. Ladies and gentlemen, thus far I've focused on the impact of the decision that the decision in Hutchinson had in England and Wales. But what impact did it have elsewhere, particularly in Scotland, that unlike the rest of the UK, does not have whole life imprisonment on its statute book? In 2019, English practice featured prominently in an attempt by the Scottish Shadow Secretary of State, by the Conservative Shadow Secretary of State in Scotland, Liam Kerr, to introduce whole life sentences. His stated ambition, in his own words, was, quote, to give Scottish judges the same power that is afforded to their counterparts south of the border, the ability to put the worst criminals behind bars for the rest of their lives. After a protracted debate, his bill was voted down in the Scottish Assembly, not unexpectedly, as the Conservatives are not in government there. What was striking, though, about the debate was that those who opposed the bill did not reject the principle of whole life sentences, but argued instead that Scotland already had such sentences in practice and that they really approved of them. Scottish judges, they explained, could impose and recently had imposed life sentences with such long minimum periods before the parole board could consider release, that realistically, the person subject to them would always die in prison. In practice, if not in name, whole life imprisonment had already been normalized in Scotland. In conclusion, let me draw together the threads of what I have been saying. A positive moment of penal reform in which the right of all life prisoners to a realistic prospect of release and to hope of returning to free society. That positive moment is being compromised by regimes that promote authoritarian populism rather than liberal democracy based on the rule of law. In propagating their authoritarian populism, such regimes draw on and manipulate not only populist punitiveness, but they also look for weaknesses in human rights-based legal reform, or at worst, simply ignore them. In this climate, the role of the states that do claim to uphold liberal democratic values is important, as they can provide powerful underpinnings to penal reform. In the case of the right to hope for release from life imprisonment, I'm sorry to say that the United Kingdom has failed this test. Its politicians have pandered to populist punitiveness and sought to undermine the lead taken. They've sought to undermine the lead taken by the European Court of Human Rights in ensuring the modest but important protection that the right to hope offers to life prisoners worldwide. British courts, too, have declined to protect these reforms when it would have been possible for them to do so. The combined approach of powerful British politicians and lawyers has lent support to the authoritarian populists abroad. It has also ensured that at home, the UK is one of the few countries in Europe that still imposes and in practice fully implements whole life sentences. This normalization of whole life imprisonment is not something to be proud of. The best I can offer as a scholar is to speak out in the tradition of Roger Hood against the manifest injustice of imprisoning people while leaving them without any realistic hope of ever being released. Thank you.
Thank you very much, Dirk. That was fantastic and very interesting. We've got a series of questions that people have typed into the chat. So would you like me to read them to you and then you can respond?
Yes, please.
Right. Okay. So the first one is from Carolyn Hoyle, and she has written, Tony Bottom's notion of populist punitiveness fits with my own understanding of what's happening in many areas of Southeast Asia, most obviously in the Philippines, but also in Sri Lanka and in Indonesia. In these countries, governments and political elites seem not only to indulge punitivism within the public, but to encourage and exploit it. So I wonder if you think opinion studies on punishment can help to challenge and thereby shift punitive discourse and ultimately influence practice. While Roger's opinion studies have focused on the death penalty, could similar work on life sentences challenge the normalization of these extreme penalties?
Yes, I think they could. I think one of the exciting things about working in the area of life imprisonment is precisely that these sorts of studies, with minor exceptions, have not been done yet. There's a great deal more that could be done. But the second point I would make is the countries of Southeast Asia are a good example of the broader point I was trying to make. You think of the Philippines, it's not so much the case of popular punitiveness rising from below. It's a classic example, I think, of an authoritarian leader using and abusing and indeed shaping to some extent this popular punitiveness in order to support his own regime.
Thank you. Obviously, if anyone wants to come back to one of the typed questions, then type in another question. But the next, just moving on to the next one, it's from Milena Tripkovich, who says, thank you for a really interesting talk. It seems to me that another example of ultimate penalties that are on the rise is the deprivation of citizenship of criminal offenders, which has been introduced and expanded in many European democracies in recent years. It is, however, difficult to qualify some of the countries that have introduced these policies, like Germany, Denmark, or Norway, as examples of authoritarian populism. Is it possible that some other factors are at work here?
Well, that's a tricky question, I think. I'm very, to take a step back, I'm very fond of the concept of ultimate penalties because with our very long and very necessary focus on the death penalty, we've often forgotten that there are, historically at least, a range of ultimate penalties. In other words, what do we do with our worst offenders? Okay, we can kill them, we can lock them up forever, but we can also exclude them from society in other ways. So there's a long history of deportation as a way of getting these people out. And I see this latest European manifestation also as an example of that. Is it an example of more authoritarianism? No. But it is an example, I suspect, of a certain, how could I put it, lack of universalism, a certain sort of nationalism, a certain sort of narrowing of the state so that it focuses more on the problems of that state. And to that extent, it does have a populist edge. And I think what we need and what I hope still to work on are studies which look at all these different forms of penalties as part of a broader process. It sees ultimate penalties as a single topic to be studied across the pieces as well.
Thank you. The next question returns us a bit to the issue, which I think you've spoken on already a little, in terms of whether the motivator for some of these penalties is actually the public. So what the role is of the public. But I'll read you the question. Thank you, Dirk, for a striking talk. This is from Julia Anderson. I have been wondering about the extent to which the punitivism is truly populist, as in coming from the people, and to what extent it comes from the media, which politicians have been said to mistake for public opinion.
I think it's a mixture. I think the politicians feed off the media feed off the politicians, and they sort of build up this pressure as they run together. On the other hand, I'm not suggesting at the moment that our public is passive. Clearly, one can exploit populist sentiments, but there must be the possibility of exploiting them, as it were. So there are complex processes at work here, and it is something which criminologists, sentencing scholars have studied. All that I'm doing is giving it a slightly different spin, as it were, I think.
So the next question is from Nicola Cisse, which is about Scotland. She's written, it's also worth considering the order for lifelong restriction in Scotland as an example of a sentence where a prisoner may have little hope of release unless deemed safe. We have around 64% of these men post-tariff. Do you have an opinion on this order?
Yes, I do. I've recently written on Scotland, and I was quite shocked to discover exactly what you've told us now. For an English audience, the order of lifelong restriction is the Scottish version of imprisonment for public protection, which has been abolished in England. But the order of lifelong restriction in Scotland is still going strong. They were introduced at exactly the same time. Their history is slightly different, though, because the order of lifelong restriction was introduced after a serious commission of inquiry, and it was a serious attempt to protect people who, to protect victims, and very often victims of serial sexual or domestic abuse, for example. But the practice has been exactly as you described. So as with the imprisonment for public protection, you have people who get relatively short orders and then never get out. And it's really a classic example of the extent to which something I haven't spoken about at all, aversion to risk can drive disproportionately long terms actually being served. Could I give a quick example? The very first, I've used this one elsewhere in a recent lecture, but it's striking. The very first person to die of the virus in Scotland was someone who was serving a order of lifelong restriction with an 18-month minimum. Well, he was kept in, he wasn't a nice man, he had a long record of sexual offenses, but he was kept with this 18-month minimum. He was kept in prison for 8 years until he died there quite recently. And this really made me sit up also and think, of how big this problem is.
Thank you. So the next question is from Lucia Zedner, and she's written, Winter was lauded as creating a right to hope, but is it arguable that for the growing population of elderly prisoners, even a right to review after 25 years arguably constitutes a whole life sentence in practice, given that they may not live long enough to enjoy a realistic prospect of release?
Yes, a good point. Winter was not confronted by such a case, of course. And the reality is that the European Court has not given a very clear judgment on what to do about older prisoners. And it's very interesting, in Catherine Appleton and my comparative study, we have a section in our book dealing with this. And it is a problem that arises in many countries. And some countries cope with it better than others. So some have, for example, expedited release for anybody over 65. There are many countries, and there are a number of countries who never impose a life sentence at all on anybody over 65, with a rather splendid explanation in the case of Russia that old people are a bit like children and they can't form very good judgments over the age of 65, which of course I find particularly troubling. But there it is.
We had a couple of people have sent in questions beforehand, and one of them was actually around this issue of the right to hope. This is from Ben Jarman from Cambridge Institute of Criminology. And he, in his question, which is quite long, he raises the issue of how the life sentence prisoners, in order to access rehabilitative opportunities and work towards release, are constantly assessed during their prison sentence, and that in those risk assessments, which are done by prison psychologists and people in the prison, they often, the criminological research has found that the prisoners don't always recognize themselves in the risk assessments, and so they end up having to sort of follow the sentence targets in ways in which they perhaps don't really agree with. And so Ben's question is, how should constitutional democracies deal with cases where prison officials and lifers themselves differ about the persistence and nature of their risk? How can they safeguard against the right to hope becoming a pretext for increased punishment through backdoor sentencing?
It's very difficult to guard against that. And it in a way is an insoluble problem, because someone has to make these judgments if you have indeterminate sentences. Having said that, I rather like the approach of the German Constitutional Court, which essentially has reasoned that it is always a matter of weighing two things against one another. And the longer that someone has served, the more you should lean towards release, while still having the release body making the ultimate decision. Secondly, although I don't think courts are perfect, I do think that on the whole, systems that have these decisions made by specialist courts rather than by bodies which can be more easily manipulated by the state apparatus are more successful. But there's no easy solution to that.
Well, sticking with the issue of the role of the courts, Adrian Grounds has written in a question saying, what do you think can be done to increase respect for the ECHR and its jurisprudence in the UK and in other European states that continue to endorse whole life orders?
Oh, that's a difficult.
It's a nice, easy question.
That's an extremely difficult question. I think, and as I hinted in my lecture, I think that in the first round, what we need is for those who really do know about the court, and by that I include, I mean particularly practicing lawyers, to take it seriously. I was quite shocked in the Winter and post-Winter process, and I only went back into this in passing in my lecture, to the extent to which our own judges undermined what the court was trying to do. So I think that's where I would start. It is inevitably tied up in broader politics of us and them, and the notion, of course, of Europe being something across the channel. And it is really a difficult question. I don't have an easy answer. Oh, I could make one further point, and that is I could say that it is probably worth emphasizing over and over the extent to which the fundamental values of the European Convention also exist in the common law. And I'm quite happy to do that. If someone says, well, the common law has always said that, I say, fine, as long as you accept that principle. So the disproportionate sentences that arise in our system because of whole life sentences from which release is not possible, it could be addressed to a large extent by the common law. And occasionally it does happen. So we do have examples where our courts have said, for example, where parole is involved, we need a proper due process procedure, not because Europe has told us to do that, but because that is fundamental to our own legal system as well.
So Jeff Fagan wrote in a question ahead of time, which again is quite a complicated question, but it sort of builds on some of these issues that you're discussing now, which is actually about what he refers to as the regime of algorithmic justice. Yep. So his question, what he writes here is, we've entered nearly fully into a regime of algorithmic justice. Decisions about transfer of minors to criminal courts, eligibility for life without parole, sentencing, and parole decision-making have been delegated to machines whose accuracy, fairness, and neutrality are highly suspect. The instruments have been shielded by the courts, at least in the US, from daylight, citing proprietary interests of their developers. Can you locate these trends in the political evolution of correctional regimes and their drift into the neoliberal, and do you see any leverage points for democratic regulation, or is the neutrality of machine justice preferable to the biases of just judges and parole bureaucrats?
Wow. Well, firstly, I would say I think the trend to machine justice, to use that term, is stronger in the US than in Europe, where my primary focus has been. I think there is much more resistance to what is really a dehumanization of justice. I can still remember when I started studying criminology in the 1970s, there was a wonderful Canadian book by a man called John Hogarth, Sentencing as a Human Process, which influenced me a lot. And I think that in this area, of course, courts, parole boards, and so on can be criticized, can be biased, but I'd much rather have them making decisions. I'd much rather have them giving reasons also for their decisions than having it done by a machine. And the reason for this, I think, is found in a wonderful line from my late mentor, Jim Jacobs, who said to me once, criminal justice reform is about whom you distrust the least. Well, I distrust this machine justice more than I distrust human beings with all their failures.
Interesting. Okay, now I'll come back to the chat where we have many, many questions. Baljit Kaur has asked, could you please speak a bit about the role mitigation could play to, or the challenge mitigation has while bargaining a life sentence with a possibility of remission during a sentencing hearing?
Okay. It's worth just emphasizing, many of the audience will know this, but it's worth emphasizing that in English law, we have a system where there's essentially a two-step process. If you're convicted of murder, you're sentenced to life imprisonment. The judge says, come back tomorrow and argue about what the minimum period, if anything, should be. That is not the most common way of doing it. Most countries in the world have a single fixed point after which release has to be considered. Initially, and for many years, I preferred the English system. I thought this is fairer. You get some good judgment on how serious this particular murder really is. And the advantage is that in theory, at least, once the minimum period has been served, the only question that remains is dangerousness, risk to society. I'm not so sure anymore. I think that this appeals to the scholar in us, neat, but human decisions we were talking about a moment ago are more complex than this. And the countries that allow that sort of discretion tend to have people released far earlier than we do here. I mean, it's worth remembering, it wasn't my theme today, but it's worth remembering that the rate of people serving life sentences in the United Kingdom is spectacularly higher than any other equivalent European country. So in England and Wales, we have over 7,000 lifers. In France, we have a few hundred. So something different is going on. And one has to look at how these processes work. So I think that the discretionary system where you argue for mitigation at the stage of setting the minimum sounds attractive. It should be a good system, but in practice, it's producing very harsh and increasingly harsh results because those terms are gradually getting longer.
Okay, there are two questions which I think are more or less asking fairly similar things. So I might read them both to you. The first is from David Hayes, and he says, Dirk, you mentioned the notion of purported liberal democracies on a couple of occasions. To what extent can we use liberal values to defend humane punishment, human rights norms, and so on, in an era where liberal political concerns seem to be drifting away from valuing freedom to providing security to a seemingly insecure public? How do you suggest that we as academics ground our defense of humanity in punishment? That's one set of questions. Then further down, Tom Dames has written, excellent talk, Dirk, and good to see you. 10 years ago, Richard Sparks wrote the following about your book with Sonia Snacken. It is, quote, very significantly more optimistic in tone and inference than the majority of recent work on prisons. Your talk today is much more pessimistic. What does this imply, in your opinion, for the future of what we once referred to as European penology? So I'm kind of joining them both because I suppose European penology was also a liberal endeavor.
They're both extraordinarily large questions. I think to try and address them together, that my talk is pessimistic, or was pessimistic, in the sense that I said to myself, well, let's try and look seriously at what's happening rather than presenting the best argument that you could for a human rights, an audience which fully bought liberal human rights principles. And I think that's worth doing. I suppose if you ask me for my personal position, I would see this, and I don't want to oversimplify, but in some ways as needing to know your enemy. In other words, and to go back to Roger's example, I mean, one of the admirable things about Roger's work on the death penalty, compared to so much that's written on it, which is mere polemic, is that I've never doubted Roger's abolitionist credentials, but he does take seriously the arguments that are going around. And that's really what I was trying to do here. And it's also my reply to David as well. I don't think that as a matter of ideology, one should give up notions of freedom and justice. I value them enormously. And as I get older, I care more and more about procedural rights and things. But we do have to recognize that these are under threat. I'm tempted to say must try harder is about the best I can come up with.
There's another question which is again rather similar to this, but more focused on the public. This is from Rose Poyser, who says, thank you so much for such a fascinating talk. You've spoken about the role of public support being used to justify, if not contribute to, the rise of LWOP. Do you think it would be possible in the current climate to encourage a similar level of public support against the use of LWOP? And if so, how?
Well, it's really the same question from a slightly different angle. Mm-hmm. I do think that one of the things that I've enjoyed about my own work in Europe is getting away from always looking at things from the Anglo-American perspective. Because if you look at Anglo-American political tendencies, if you look at Anglo-American debates, there's every reason to be pessimistic. But there are many countries where seriously people, the vast majority of the population, think it's crazy to have a system that locks up people forever and lets them die there. I didn't use it today. I use it in almost every talk that I give, I think. The jurisprudence of the German Constitutional Court in the 1970s, because the Winter decision is very much based on that. And at its core is the idea that the most fundamental human rights, the right not only to freedom but to human development, depends on a right to be a member of a free society. And where it comes from is the German court being asked the very direct question: can we have life imprisonment in a democratic state that believed in rights? And the answer was, yes, you can, but only if it provides for real opportunities of release. And it can only provide for real opportunities of release, which is something I didn't deal with today either, if you provide within prison the possibility for people to improve themselves. And I think those two go together. And I mean, all of us that are criminologists and who study crime are dealing with people that the vast majority of the public find very unsympathetic. And it's particularly true when you look at people who commit the sorts of offenses that arise in the ultimate penalties, whether they're death, life, or expulsion. And I think, without trying to sound too sort of saintly about this, I think there's a real purpose in saying, hang on, even for these people, we have to look very seriously at what we're doing and what we're trying to impose on them. And I think that does have some cut through. Oh, I hope so anyway.
Thank you. There are a number of questions which are about specific jurisdictions. I'm not quite sure. I mean, I'll ask you, we may not get through all the questions just so that people are aware of that, because we don't have too much more time. But the next question is from Alison Ewell, and it's about Canada. And she said here, in Canada, we have an indeterminate sentencing scheme whereby certain individuals labelled by a judge as dangerous can be sentenced indeterminately. This scheme has been upheld constitutionally on the basis that there's a periodic review mechanism, first after 7 years and 2 years thereafter. Despite this review mechanism, research shows that less than 2% of dangerous offenders ever achieve release. What are your thoughts on this problem?
My thoughts on this problem is that we really have to recognize that these indeterminate sentences are life sentences, and often very harsh life sentences. And it's absolutely true. It's the same with the order of lifelong restriction in Scotland. But very often, even the most basic rudimentary framework of proportionality is lost completely in these cases. And the only thing we can do is to reassert them. So we have the order of lifelong restriction, you have the indeterminate sentences in Canada. In Germany, you have the same problem, because in Germany, you have life imprisonment, and then you have a second sentence of a sentence for public protection, in a sense, which is sometimes worse than life in prison. And you've had one or two cases where a court has imposed both. It's imposed a life sentence, and when the life sentence is served, go on to one of these other things. And that just has to be stopped. I mean, that is on the basis that this is so grossly disproportionate that you can't deal with it. And in the most elementary sort of sentencing philosophy, gross disproportionality. I remember Andrew Ashworth and I years ago wrote a paper along these lines. Gross disproportionality always needs to be a sort of backstop, and it becomes particularly important in these indeterminate cases.
Sticking with the jurisdictional examples, Harriet Burgess has written in saying, thank you for the fascinating talk. In Ireland, recent legislation reforming the parole board has increased the review time for life sentence prisoners from 7 years to 12 years. This was apparently done as life sentence prisoners in practice were not being reviewed at 7 years, and it was to give prisoners a more realistic idea of when their sentence would be reviewed. However, there does seem to be an increased tendency towards the rights of victims in parole hearings, and the idea that Irish life sentence prisoners never actually serve life in prison has gained currency. Would you view these changes as a shift towards popular punitivism in Ireland?
Oh, that last bit is very difficult. What I do know about Ireland is, as the questioner suggested, is it had a system which, until very recently, which bore no relationship to the legislative framework. And I think there was a case for legislative clarity, because my recollection of Ireland, and I don't have my notes with me, my recollection of Ireland was that people were serving longer than 12 years anyway. And it was really quite an extraordinary system in that sense. And I do believe that clear legislative rules help. They're not a solution. Someone has to make that terrible decision, or that terribly hard decision, on whether to release an offender, and I use the term which I know is not politically correct, but someone who's offended and who really may be very dangerous. At one stage in my career in South Africa, I actually sat on the board that did this. And it is a very, very difficult thing to do. And the only way I justified it to myself, I said, well, someone's got to make these decisions. I may as well be one of them, but it's not easy.
Nitika Vishwanath has written in saying, thank you for that excellent talk. How do you respond to the concerns of recidivism with life imprisonment sentences that allow for the possibility of release? Is there any empirical basis for fears about recidivism, and what are your thoughts on this?
The traditional criminological view is always to say the rate of recidivism is very low when it comes to people released from life. And that's true. On the other hand, it is true that some people reoffend. We don't have complete statistics, but I know when I was, when Catherine and I were working on the book, one of the things I noticed was that a large number of people in England who got whole life sentences were getting them for a second offense. And Mr. Winter was an example of that. Mr. Winter committed a murder, I know it's a terrible thing to say, but perhaps not the most serious of murders. He was out after 10 years, and then he committed the second murder. Again, they were massive, to use an earlier question's word, they were very, very significant mitigating circumstances. He was absolutely distraughtly apologetic, he pleaded guilty and so on. And the court said, second murder, someone never to be released again. So it does happen. And again, it's this question of risk. At some point, one has to take the risk, but you can't be, I mean, there are some people, very, very few, but there are some people who, if you sit on these boards and try and make a human decision, you've got to say, look, as far as I can judge, this person still is dangerous.
Mm-hmm. So 2 questions now, which are both around the issue of age. So Gavin Dingwall's written in saying, hi Dirk, I enjoyed your talk immensely, thank you. A further issue is the use of indeterminate, indeterminate sentences with child offenders. Are there any comparative trends that you have observed? So that's his question. And then Chris Slobogan has written in saying, the US allows mandatory LWOP except for juvenile offenders. Giving up on retributive arguments, advocates have contended that LWOP is expensive and it's costly, and that people given LWOP are often not dangerous, especially after age 40 or 50. Do these types of arguments work elsewhere? So they're both about trends and dealing with.
Okay, the short answer is yes, they do work in many jurisdictions. It's the minority of countries in the world that have any form of life sentence for children. The Convention on the Rights of the Child outlaws LWOP, whole life sentences for children, full stop. But it's also been interpreted as saying that you really ought not to be imposing life sentences of any kind on children ever. Most of them are found in the English-speaking world. And there are various euphemisms. Detention at Her Majesty's pleasure is one. But sometimes the judges actually say, well, I'm imposing a sentence of detention at Her Majesty's pleasure on you. But we all know that really means a life sentence, and that's what you're getting. You know, when explaining to the person being sentenced. On the other hand, some very liberal countries have used indeterminate sentences for children. There's one child in prison in Norway, a girl who was given an indeterminate sentence at age 15, I think. And it was a terrible case. This was a case of someone who had been found to be very violent. They had all sorts of warnings, and then she went and killed someone. And the court said, hang on, we've just got to impose an indeterminate sentence. So, and in this country, we use them a lot. The biggest problem here, in my view, is not so much an indeterminate sentence for a child, but how incredibly long the minimum periods imposed by the courts are. The courts reduce them a bit, but we've had a series of cases. In fact, I've been politically involved in advising on one of them, where you have, let's say, a gang of youths aged 16 who stabbed someone to death in a joint enterprise sort of case. They get life sentences, and then the court says, well, the minimum period is important. Normally we would give, I don't know, 25 years for a minimum period like this. This is a juvenile, so we give them a life sentence with a minimum of 20 years. Now that seems completely out of proportion to me, because the big thing is that if you were to give someone age 16 an indeterminate sentence, the only reason for doing it is you really want to see whether they will still be dangerous. So my own view is you could probably manage without any life sentences for children. In very, very rare cases, they may be necessary, but you need far stricter safeguards, you need far shorter minimum periods, and you need a presumption in favor of release, a strong presumption in favor of release. Yeah, I could go on, but that's probably it.
Okay, I think this might be the last question that we go to. I know the time had been set for longer, but I feel like I'm kind of grilling you with quite so many questions. And I said we'd have about half an hour for questions, and we've already had about 40 minutes. But anyway, this is from Max Stour, who says, thank you for the talk. What is your view on the current quality and sufficiency of interaction between constitutional law and criminal law in advocating for humane punishment? And what, if anything, should be done to improve this interaction? The debate on punishment rarely seems to be in the center of contemporary constitutional discourse, at least in the Central European countries you mentioned.
Well, I was going to say that before the last line, but I think it varies from country to country. I do think it's important. I myself have found, I would see myself as a criminologist, a criminal lawyer, but in the last 10 or 15 years, I've really enjoyed immersing myself in one area of constitutional law at least. And I think it's valuable, but it depends greatly on what constitution you have. So I've given the German example. I've given the, Professor Segovin's spoken about the US. I've often wondered in this country, where we have a Bill of Rights, which, like in the US, outlaws cruel and unusual punishment, why lawyers have not made more of that. And I do think that thinking through what does it mean to be a citizen, what does it mean to be a human being in a particular country is very important.
I know I said that was the last question, but there's just one more that I think maybe just to take us back to the content of the direct content of your lecture. Anna Maria Margari, and I apologize to everybody whose names I'm not pronouncing correctly. It's my Australian accent. I would like to thank Dirk for this interesting talk and to remember the strong dissenting opinion of the Judge Albuquerque in the Hutchison case. What are, in your opinion, the political reasons of the ECHR change of opinion from Winter to Hutchison?
Well, the hidden reference, and if I ever were to publish my lecture, the footnote would be precisely to Judge Pinto de Albuquerque's dissent in Hutchinson, and also a more recent case. He's an extraordinarily interesting judge. He's the first judge to adopt a principled abolitionist opinion towards life in prison. And he's recently retired from the bench. He's a Portuguese judge. And that matters because Portugal is the country in the world which for the longest period has had no life in prison. And one can make systematic arguments, which he makes very well, against that. But interestingly enough, he has also consciously given separate concurring opinions and dissenting opinions to try and bolster the sorts of arguments that I've been making against whole life imprisonment. What he says is what I've said in my lecture, that he thinks that the pressure told on the court in Hutchinson's case. He would say so publicly, very unusually for a judge, but also privately. And if one's interested in that, in the politics of this, what runs together weirdly is the question of prisoners' right to vote combined with these life cases, because they are two very, very high-profile cases which combine criminal punishment and human rights law. What is relatively unknown in this country is how few decisions there are against the United Kingdom. They're very, very few compared to other countries, but they just happen to be the two things that have caught the public imagination, encouraged by politicians, as I've been arguing.
Okay, I think we'll stop there because you've answered many questions. There are still more, and so I'm sorry to those of you who have sent in questions that I haven't read out to Dirk. Thank you very much for all of those who have sent them in. One question which was asked a few times is whether there will be availability to access this lecture, because I think a few people came in late, and so it will go up online, and you'll be able to freely watch it. We will tweet it and do all of those sorts of things that we're all doing now. And it really just leaves me to say thank you very much, Dirk, for doing this, and I'm glad we got through that. And actually, it was very good. I'm sorry that we couldn't see all the people in the audience. People are now saying thank you and congratulations and good discussion. So thank you very much, everybody. And hopefully next year we will be able to welcome you all in person to Oxford. And Dirk, we are definitely going to have you to the dinner next year. So goodbye, everybody. Goodbye. Thank you. Bye.
Bye.